How old are you?
31.
31. You need to make a decision on whether or not you want to spend the rest of your life in prison or in custody, right?
He wanted prison and showed no regrets. Watch how Judge Boyd handled this situation.
Court is calling 2023 CR 7862, State of Texas versus Joel Singleton. Can I have parties announced for the record for the state?
Hank Wilkins for the state.
Defense?
Miguel Hernandez for the defense.
And are you Joel Singleton?
Yes, ma'am.
All right. Are there any applications in this case?
No, Your Honor.
All right. Probation, no application. Counsel, have you received all the discovery and did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Singleton, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Ma'am.
I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney and did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are waiving count 2 and 3, Judge, and only proceed.
Any objection?
No objections, Your Honor.
Mr. Singleton, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years. I'm sorry, you are proceeding on the repeater count?
Yes, Your Honor.
Okay.
As well as the deadly weapon allegations.
All right. Did you understand the offense of aggravated assault with a deadly weapon is a second-degree felony? Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine.
Yes, ma'am.
If the state proves the repeat offender allegation, then the range of punishment will be anywhere from 5 to 99 years or life in prison. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Singleton, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, state is proceeding on count 1. You agree that you've been convicted of 1 or more felonies for enhancement. Punishment is to be assessed at 10 years in the prison. There's a $1,500 fine, affirmative finding of deadly weapon. There are no applications. State will take in consideration 2023 CR 7863. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea. State is at the plea.
Yes, sir.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counselor, have there been any such motions?
No, Your Honor.
Next, I'm going to show you outside the agreement. State is requesting there be no contact with Victor Perez and Xavier Solomon. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to count 1 in an indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And to the repeat enhancement paragraph, how do you plead? True or not true?
True.
State any evidence.
Your Honor, I offer State's Exhibit 1 and the attachments.
We've had a chance to review, Your Honor. No objections.
Mr. Singleton, State, you may continue to confer. Mr. Singleton, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Say this, that's a dismissal of that other.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty of count 1. The court will find the repeater enhancement allegation true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We would ask that the court go along with the plea bargain agreement that the state has offered, Your Honor, and my client has accepted and taken responsibility for.
All right, the court will follow your agreement, sentence you to 10 years in the prison. There's a $1,500 fine, time and money to run concurrent. Take in consideration 2023 CR 7863. Give you credit for any time served. There's an affirmative finding of deadly weapon. There's to be no contact with Victor Perez and Xavier Solomon. Is there anything else with regards to sentencing?
No, Your Honor.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Mr. Singleton, this is the state you're in your life. You need to, how old are you?
31.
31. You need to make a decision on whether or not you want to spend the rest of your life in prison or in custody, right? So in Texas, if you come back on another case, you will end up, if it's a felony, you'll end up being a habitual. And depending on what type of felony that is, your minimum would be 25 years in prison. Do you understand?
Yes, Your Honor.
You're going to wake up and you may find yourself in your 50s. You don't want to do that, right?
No, ma'am.
All right, good luck to you. Take care of yourself.
Thank you, Judge. May I be
You're welcome.
excused?
You may be excused. All right. Who's here in Joe Serta?
I am here.
And then after that, the court is taking its lunch break. All right, so what is happening with Serta?
Your Honor, we have a little bit of a unique situation here. We have an offer. It's an opposed offer. Mr. Serta was on probation and at Escosa for DWI also, and he's been sentenced to SATF as part of an NTR, and he's going in on the 29th of this month. And so this is sort of new here. I don't know how the court wants to handle it. My preference, if it means anything, would be to delay our hearing until he gets out of SATF. I don't know. Mr. Serta said that his probation officer said they wouldn't bring him over here. I said, well, that's going to be up to the judge if they bring him out of SATF or not. So I don't know how the court wants to handle it. I've never had a situation.
All right,
like
so
this.
I'm going to think on that. We're going to come back this afternoon.
Okay.
All right.
All right, thank you, Judge.
All right, everyone. See you back at 1:30.
Can we get a setting on our case real quick, please?
Who is your case?
It's Michael Solis. Could have it on there.
All right, Donna, you can leave. I don't have a Michael Solis. Oh, here it is. Sorry. All right, why are we getting Solis, come down. Why do we need a recess?
Judge,
a
it looks
reset.
like this will be a contested MTR at this point.
All right. State,
Yes,
they're saying they want to contest it.
Well, I was talking to Mr. Wilkins
Okay,
about
sorry.
this.
I'll let her take care of it. Yes, ma'am. We don't have the lab stack. The new number ones are pretty recent and we don't have the labs back yet. So I was thinking, Judge, if we could get this set for a contested, that might give us some time to get the labs back.
All right, because I'm assuming there are other allegations in this motion other than things that need laboratory testing.
Yes, ma'am, that's true.
All right, so Ms. Ferguson, Set this for a contested hearing, second week in January, if that's possible.
We do it the third week, Your Honor, please. I've
right,
got
what's happening?
something planned on that second week, the first and second week. I usually don't take any vacations during the year.
Oh, you're taking a vacation?
I hadn't had a vacation in about 3 years.
So are you taking a vacation?
I'd like to,
Okay.
with the court's,
He's still not answering my question. Do I have to put him on the oath? Are you taking a
I
vacation?
wouldn't be taking a vacation if the court schedules me for court that week.
So what would you do on your vacation? Are you just gonna do, is it gonna be a staycation or?
Usually I would like to go out into the woods and commune with great nature.
Oh, wow. Okay. All right, Norma, set this in the third week. Your attorney wants to commune with nature. All right, January 18th, contested hearing.
Thank you, Judge.
All right, you're welcome. I miss your flower postings.
Oh, we're in the fall, Your Honor, in August, and there's not wildflowers are
But-
typically.
But usually you'll have something, a bird or something you would see, or a sunset.
The sunshine.
Yeah, just a second. All right, so everyone who's not done, you're coming back at 1:30. So that's gonna be Fabian Cardenas is at 1:30. Isaac Brandley, 1:30. Roseanne Garcia with Stenberg at 1:30. Griselda Rosales, that's 1:30. And that's on page 7. Amicus, that's 1:30. And that's on page 8. On page 9, Serta, that's 1:30. Jason Guerra, 1:30. Have we done Jose Sanchez? No, ma'am. All right, Jose Sanchez, 1:30. And Josiah Williams, 1:30.
Judge, you just put that on the document.
Yes, so we'll see if that's done. So those are the cases that are coming back 1:30, so we're on recess till 1:30.
Your Honor, may I ask?
The case of Texas versus Joel Singleton involved the charge of aggravated assault with a deadly weapon, enhanced due to a prior felony conviction. In a straightforward hearing, Singleton pled guilty and true to the repeat offender allegation after confirming he understood his rights and the plea deal. Judge Boyd reviewed the stipulated evidence, found him guilty, and followed the state's recommendation, sentencing Singleton to 10 years in prison with a fine. The major turning point came after the formal sentencing. Judge Boyd went off the record to deliver a stern personal warning, telling Singleton he needed to ponder his future. The judge emphasized that another felony would label him a habitual offender, carrying a minimum 25-year sentence, urging him to change his path.